service and the formation of work groups related to very specific topics that relate to groups of policies that will enable us now to move to the next layer of consideration, that medium layer of policies that will take more attention, and you'll be seeing eventually documents with redlining and so forth, as opposed to what we have been doing, which was repeals and then policy adoptions based on various criteria. You know about what we did in the last two meetings. So today we move forward on that, and we have two other motions that relate to issues that we've been waiting to deal with, and today's the perfect day for that, having the time to do that. First turning to the minutes, for the minutes of November 19th, 2014, do I hear any comments or questions about those minutes? Seeing no hands, the minutes are approved. Now we move to December 10th, 2014. Are there any comments or questions about those minutes? Seeing no hands, the minutes are approved, and we move forward to the State of the University address by our interim president, Scott Coltrane, and there will be questions following his remarks.
Thanks, Rob. So today I'd like to talk about three things, fairly short and informational, mostly updates, but I'm happy to take questions. And also, Dean of the Libraries, Adrian Lim, is here today and will also be following up on the tail end of my remarks to talk about the electronic documents issues. So today I want to focus a little bit on the policies work, on the comprehensive plan to address sexual assault, and then talk about the electronic documents. So as Rob referred to, and as you well know from what your agendas are shaped like, your mini meetings this term and moving forward, we're in the middle of reviewing hundreds of policies following the shift to self-governance. The policies are to be used, they used to be housed by the State Board of Higher Education or in the Oregon Administrative Rules, management directives, other state-level policies. And in order to ensure that they're current, relevant, and applicable to the university, we have to go through this fairly laborious process. We're making good progress. We need a new policy path forward for how we are able to enact new policies and reform or revise the policies we have. And to that end, as you hopefully have followed, we've now appointed all members of the Policy Advisory Council, and they will meet for the first time next week. The Policy Advisory Council includes President Keir or whatever sitting president of the Senate, as well as other faculty, staff, and students, and we're looking forward to a well-functioning group. They'll advise me as president on prioritizing and organizing the review process so that all the various departments and people on campus who are affected by the policies have input. So part of your agenda today is looking at the work groups the Senate will have to be able to have good input into that process. Also working with the Senate and Trustee Susan Gary, we're right in the middle of finalizing a policy on policies, and I note that it's on your agenda to bring forward to the University of Oregon Board of Trustees for consideration. And that will happen after you have, it's one of your items today, but I believe you will take action on that at your next meeting. I want to give a special thanks to John Bonine and President Keir for helping to move that process along. It's been a really good collaborative process, sitting down together, figuring out what needs to be in that document. We've worked hard to hammer out language that works with the board and also to ensure the Senate has oversight on academic matters and still allowing the university to be organized and efficient in ways that it needs to be going forward. I want to thank this body for all your work reviewing the policies. Some of the easy parts have been done. It will get a little more difficult as you dive into the policies. We really appreciate the work that you're doing, really engaging those. Recommendations are currently under legal review, so the ones that you've already dealt with, and as part of the Policy Advisory Council's initial work, we'll solicit any additional campus input, and then I'll act on those recommendations as set forth in the Constitution within 60 days, or return back to you to suggest amendments if there's any disagreements. So as a campus, we're beginning to make some headway, and that's great because we've got lots of them. The other thing we're making headway on is our strategic planning effort, and I know President Keir and maybe Provost Burnett will comment on that right after I'm done. So let me say a few words about the comprehensive plan to address sexual assault. We now are moving forward with how to put together the 3 different reports and how the campus is going to move forward. I invite everyone to come to a couple of town hall meetings that we've now scheduled. The first is on Tuesday, February 24th at noon in the EMU ballroom. The second is the following week, Monday, March 2nd, 4 p.m. in the Ford Alumni Center. And what we'll be doing is having these be town halls where there'll be facilitated discussions designed to help inform the campus about the different recommendations. Some of them fit together quite nicely, some of them less so, so we need to be able to prioritize them. I'll be able to report out on which ones might be doable in what order and get your feedback on that. There'll be an opportunity for both the written and electronic input, so my office will be providing more information on how to participate on that process very soon. I'll report just briefly that the Campus Climate Advisory Group for doing surveys of sexual violence has met several times, and it will help oversee the administration of campus climate surveys on campus. As you'll remember, I signed on because of the deadline to participate in the AAU effort, but I'm still expecting this committee to advise me on whether that's a good effort and how we move forward with that, as well as doing our own survey, and we'll have updated reports as we go forward on that. The goal really for the winter term and into the spring is to get put all the information together that we have and really forge a comprehensive plan for how we're going to, which initiatives we're going to do in what order, and how we can make sure that we reform what we're doing in the best possible manner. As part of the university's commitment, in December, the Senate recommended some changes to the Student Code of Conduct, and I just sent a letter to President Keir. The Senate had voted to clarify that these are policies proposals rather than legislation. The response that I sent to President Keir are that we're considering those, in conjunction with all the other codes, and this will be moving forward as planned. That work hopefully will be expedited. We'll look at them as a package, so part of the correspondence back is not to have each one of them piecemeal have the 60-day limit, but rather to consider them as a whole, because I think they really are a package. And some of the recommendations from the President Review Panel versus the Senate Task Force are somewhat different in whether the code should be totally separate on the issue of sexual violence or whether it should be integrated, and so we'll have to adjudicate between those. Finally, I'd like to talk briefly about the issue of the electronic documents that were released that you might have heard about. They did not go through the typical archival processing procedures and were released without that kind of review that we normally expect. The university has now received the documents back, so now we'll have a chance to properly review what's actually in them and process and archive them in the fashion that we normally would attempt to do. We're still investigating what happened, so we want to make sure that something like this doesn't happen again, that we're not releasing 22,000 pages of documents that weren't reviewed thoroughly, and we want to make sure that doesn't happen again. But it is a personnel matter, so I won't be sharing details about what led to the return of the documents or any of the parties involved, but we're very happy that the action was taken to return the documents, and I think that was the right thing to happen. I would like to explain a little bit about why the university sought return of those materials. I mean, what was going on with that. And I think it really comes down to our moral and legal obligation to our students and to our faculty and to our staff. These were presidential records, so all the electronic records of the president's office from going back 4 years, so that's 4 different presidents. And these were the typical fashion is that those are just shipped over to the archives office without any kind of vetting or culling or taking anything out. No judgment about what should be in and what should be out. They're just sent over to the archives office, and then there are standard practices, some set by state law, about how those should be made available to the public, because we're a public university and we want for researchers and others to be able to work with those documents to look at the operation of the president's office. But included in those are all this detailed stuff. I mean, of the 22,000 pages, which I have to tell you I've not looked at very many of them at all, there's lots of just trivial stuff, thank you notes and handwritten correspondence, And there's lots of sensitive stuff. So the president's office is sort of the office of last resort when anybody wants to complain about anything. Or, you know, I get a lot of stuff from parents, you might be surprised, that are relatively private. I mean, they're saying things about their students that are protected. There are allegations against faculty members that might not have come to fruition that are in there. There's just lots of stuff that you wouldn't want revealed to any third-party source because it's just not public. And people, I think, trust the president's office to keep that stuff private. So what we've got to do now is align our archival processes for, you know, looking at the needs for public review of presidential politics and operation of the university, and balance that with the privacy concerns. So now, having the documents back, we can look at both what went wrong. That'll be an investigation. It's an outside legal firm, and we'll know about that here in the next few weeks, and we'll figure out how we can both fix our process and also clean up whatever changes we need to make sure that we're following our own internal processes. So throughout this, I've learned more about the process and have come to respect greatly the work that the library does and Special Collections does in terms of archiving, but just in terms of general things that they do. So I asked our Dean of Libraries, Adrian Lim, to talk to us a little bit about some of the complicated issues about how there are different missions that the library must follow, both as archivist and as a library, and they have quite a bit of capacity to deal with the complex privacy rights, and on a daily basis they're both trying to protect access to documents as well as protect privacy. So I just want to say to you as Senate members, the President's office is fully committed to making sure we don't leak documents, that we don't let private records out, but also committed to the public access where appropriate to those documents, where they should be shared, where it's timely to be shared. And so we'll have to work on that together. So with that, I'll invite Adrian Lim to come up to speak, and then both of us can take questions after she's done.
Good afternoon. As a new Dean of Libraries, I feel honored to have joined the University of Oregon 6 months ago, and to begin my work with some of the most dedicated, creative librarians, library workers, faculty, staff, and students that I've ever known. I truly wish that my first remarks in front of the Senate would have been allowed to highlight the many outstanding library programs, services, and resources that we provide for you in the libraries. But instead, I find myself needing to address the recent records release incident that occurred. For almost 2 decades, I have served as a librarian and library administrator in large public universities. As many of my colleagues in the libraries have also done, I've dedicated my life and career to helping students, faculty, community members obtain the outstanding library services and resources that they need to succeed and transform their lives. Since 1996, I've also been an active member of the American Library Association as well, and have been a passionate advocate for both open and transparent government, equal access to information, and the protection of individuals' privacy rights, which I believe are universal human rights. I believe that this recent records incident was related much more so to the UO Library's records management role than its library archives role. Some of you may not be aware that the libraries handles a significant portion of the university's records management infrastructure, including records from units like the President's Office. Some of the records we handle are non-permanent and are retained for a limited period defined by the university's records retention schedule. Other records are permanent and are placed in the university archives after transfer from the originating offices and appropriate processing by the libraries. The Oregon Public Records Law defines categories of non-exempt records, that is, subject to disclosure, and exempt records, not subject to disclosure. Both non-permanent and permanent records may fall into either category. When exempt records or federally protected data are released to unauthorized users or unauthorized use is made of that data, we are bound by our legal and ethical obligations to disclose the breach, not only by notifying data stewards at the institutional level, but also by notifying all those individuals whose privacy and confidentiality may have been compromised. The university has an obligation as well to try to secure the return of the data. On a daily basis, we in the libraries adhere to our professional code of ethics, including those of the American Library Association and the Society of American Archivists. These codes inform our philosophies and practices and our protection of patron privacy and confidentiality. However, as fellow librarians at the American Library Association's Office of Intellectual Freedom have affirmed, libraries and archives are within their ethical rights to conduct internal investigations when they suspect that a data breach has occurred, or if they suspect that library users have not complied with institutional policies, library policies, or the law when they use library services and resources. If a data breach occurs, or if a violation is suspected, however, the library maintains its commitment to keep any internal investigation as confidential as possible, especially when personal matters are involved. I believe in openness and transparency, as many of you do, but not at the expense of the privacy and confidentiality of ordinary citizens. As librarians, archivists, and records managers, we have to balance our interests in promoting openness and transparency with our interests in protecting the privacy and confidentiality of individuals, especially when that information may also be legally protected. In closing, I know that my library colleagues and I look forward to strengthening our library policies. We do that all the time. And we have obtained an expression of support from the Senate's University Library Committee to help us complete this review over the next few months. My library colleagues and I remain dedicated to carrying out our mission with integrity, dedication, and passionate commitment to serve all of our constituents well. We hope that you will continue to support the libraries and allow us to support you in all of your teaching, learning, and research endeavors. Thank you.
Is that better? Still not on? Okay. Sounds good. This is a question from Ms. Lim, I think. Dean Lim, sorry. My apologies. So my concern, just to make it obvious, I'm the person who obtained these presidential archives from the university library. My concern, having looked at these documents, is that there are many things that are missing from them. And in particular, I would see email messages that discussed the attached, there's documents attached to this email. It would say that in the email, but there would be no attachments. And so while I understand and I appreciate your concern about the potential release of illegal documents, I can say I've been very careful not to do that. The only thing I've posted on the internet is a legal opinion from the President's General Counsel, the former interim President's former General Counsel. And so my concern is not that too much has been put into the university's presidential archives. My concern is that there are obviously some important things missing. And so I'm wondering whether the investigation conducted by this Kirshner Hunter firm will also consider that possibility.
Well, if I may, I believe that that investigation is more related to this particular incident and personnel matters that are involved. But after that is over, we plan to review our entire process surrounding records management, public records, how we treat them, etc. Now, I've gotten very familiar over the past few days with the public records law. And there are many sections in that law that really spell out the types of records that should be public and available for scrutiny. I would be the first one to advocate for that openness and transparency. Now, of course, we handle the records management, but we may not have control over some of the documents coming to us from a variety of units that enter into our archives. But again, if we look at this throughout the entire university and try to increase transparency and openness as much as we can, I think that this will improve over time. We'll be looking at it and reviewing it.
Thank you. And I assume that those meetings will be public.
I would hope so, yes. If they're conducting the public business, they should be public and open, yes.
And thank you. And then I just have a quick question for Scott. So, Scott, the one document, there are a few little emails, but the one document that sort of caused all this trouble was the legal opinion. And so obviously I'm very concerned about the release of those legal opinions. This one was clearly about faculty governance and how the university would be run. It proposed a drastic change. But my guess is that there are many other legal opinions that really should be shared with the public and with the Senate. And so I've made a public records request for some of those opinions. And the response was very quick and very clear. You have not waived your attorney-client privilege on these sorts of documents. Are you willing to do that, at least in some cases?
Well, I'm certainly willing to talk about it. I think attorney-client privilege is important. There are lots of decisions the president and other parts of the campus need to make decisions based on sound legal advice. And that was a hypothetical. I mean, obviously, the recommendation of that...
We would like to see that sound legal advice as well, I think.
Sometimes the questions asked need to be very narrow, a land deal, or, there's lots of things that I wouldn't want released. Some things I think I would like to share. So I'm happy to talk with the Senate about under what conditions which legal opinions should be shared. That's one that, had it been shared at the time, would have been fairly inflammatory, I think it's safe to say. But you'll also notice that advice was not taken by my two back predecessors.
Not all of that advice was taken.
Little as possible, as far as I can tell. Anyway, I'm here to say I don't want to undermine the Constitution. There was some advice in there that I wouldn't have taken either. And I think having more open dialogues about those kind of advice is a good thing. But it's sort of a case-by-case basis on which ones to release. Sure.
Just one other remark. As I said, I've gotten so familiar with the public records law over the past few days, and there's a large section in that law that talks about there is the public right to scrutiny, but there is also that other exemption of some things, and it talks about the public's interest in allowing its public agencies and institutions to be able to freely consider options and plans, and so I think there is a public interest in some of that as well. And that is in the law, if you just want to go and look it up.
Romance languages. There are three little questions. It's about process and policy and resources. I am a little perplexed as to why so much data would leave the president's office untriaged and unfiltered. I'm curious about whether it's really the library's responsibility in our policy to have to triage that. And as a member of the ULC for half of my career, I know we have never had the resources to have for the library to carry out that work. What do you think, Scott?
I think it's a philosophical question. I think we need to bring to the table the Public Records Office and then the records retention laws and rules all bring to bear. How much should we be sending? Is it appropriate for the President's office to, kind of selectively prune at the end of it, that would kind of seems not quite right to me. But somebody ought to do it, and somebody ought to do it systematically in ways. And probably, I think most places have a waiting period where it's not necessarily, it's more historical interest than fresh current. So that may not be as useful to you all as you're trying to help make policy. But I think we have to figure that out. So I think once the investigation's done and we find out what happened in this case, we need to look at the university, different offices, and then look at the staffing. Should it be in the office? And we'll have conversation with the Dean of Libraries and the public records office. Should they be consolidated in some way? I don't know. I think that all that'll be on the table.
I just wanted to add it as a coda that all of the communications coming from the president and the provost have pointed to confidential faculty records and confidential student records, and that should certainly be triaged. That doesn't have to be done by an archivist. That can be done before it leaves the president's office.
I tend to agree with you, but we'll have to work that out. Jennifer?
I have a comment, and is this on? Okay. I have a comment and a couple of questions about the AAU survey plans. Is this working? Yeah. Okay. So, starting once more, I have a comment and a couple of questions about the AAU survey plans. The comment is that I'm always really heartened when you tell us, just today and earlier, back in December, and have written as well, that you will take advice on the AAU survey after your advisory group has had a chance to give you that advice. But earlier this week, Around the O released a story saying that the University of Oregon was going to participate in the AAU survey. And my comment is that it seems a bit like doublespeak to say we are going to participate and that you're reserving the right to maybe not. That's the comment. The question is about the process that the university is going to undertake to review the ethics of this planned survey. As you know, because I've sent you a letter about this, I'm deeply concerned about the ethics of the survey on a number of grounds. At the time that I and some of my senior colleagues around the country wrote that letter, we assumed that, of course, the survey would be reviewed by university IRBs, including the University of Oregon. But questions have started to be raised, and we have started to hear that maybe the university believes it can do this ethical consideration without going through the IRB. And so my question for you is, your understanding that if you decide to go forward with this AAU survey, that it will get a standard IRB review?
My understanding, it will get an IRB review. I don't know the difference between standard and expedited, but I don't think there's any plan to have that be any different. In fact, the AAU document said this has to go through campus IRBs. They'll be providing some of the documentation because they're doing. Have you seen the survey?
Yes. So
I haven't looked at it yet.
It's already not standard in any way that I've ever heard of, because the materials that have been circulated have indicated that IRBs cannot make changes to the survey, which is exceedingly bizarre, really, for research. And the ethical issues touch on every single one of the fundamental principles known as the Belmont Report on what should guide the ethical decision-making of research. So that includes justice and beneficence and respect for persons. As just one of many examples in our from the letter that I sent you already, the proposal is to ask every single student at the University of Oregon to participate in this study, and then to only select the data from some subsample for actual analysis. And my review and my colleagues' review of the materials suggest to us this will not be clear to students, that they may put some amount of their time, their soul, and their heart into completing a survey that won't be used. I would argue that this raises questions about respect for persons by Belmont standards. For another example, the survey produces a definition of sexual assault. It uses the word sexual assault. It starts out questions about victimization, specifically on physical force. And I would argue that this is an intervention that communicates to students a certain picture of what it is to have non-consensual sexual experiences that is actually at odds with what we know from empirical research is the most common form of unwanted sexual experience among college students, as well as at odds with what we know from empirical research as to what causes harm. So I would argue that this survey raises significant ethical issues, and it would seem to me extremely important this be put through very close ethical review unless the university has the wisdom to realize that this is probably a problematic survey.
Well, thanks. These are important issues. That's why I need this committee to advise me. There are, I think, 3 other AAU institutions that are doing the AAU survey, which I understand the reasons for standardization and maybe lack of change to whatever document they end up with, and doing their own surveys. That's University of Michigan, Michigan State, and us. There may be others, and I think there's something on the order of 30 other AAU institutions, all of whom dealing with their own IRB. So these are the things I want the committee, the advisory group, to advise me on. We had to commit to doing the AAU survey in the beginning and commit to paying. At some point, if we find it's not meeting our needs or the ethical things are too large, then we can say no. I don't know how to predict that. I think these issues, survey, random sample survey versus census, that's a sort of a competing a view of how public health versus social survey experts think about these things. That's why I need this group to advise me.
Okay, but just one more, just to be totally clear for the record, that the documents from the beginning, from November, and the documents that were released to participating universities at the end of December make clear that the plan is to do something I've never heard of in research, and I've been doing research for a long time, which is to invite every single student to participate, but then only use a subsample for analysis. So this is on the surface a census approach, but at the data analytic level a sample approach. And the problem, among other things, with this approach is, one problem is what students believe they're doing with their time. Another problem, of course, is the implications this has for science at every single university doing this if the students are getting intervened with in the very act of going to participate in this survey. So this, I don't think we can summarize this as census versus sample. This is some hybrid I've never seen before that raises enormous concerns.
So you and I will both have to talk to the advisory group and we'll work it out. Other questions? John.
I have several. First of all, I'm sure you're quite aware that the survey, you talk about standardization, the survey is done for political purposes. It's very clear that Hunter Rawlings, the head of the AAU, stated the reason for this survey is to get out ahead of the White House and to create information that can be used basically for political lobbying. So I think it's important to keep that in mind as you consider the balance, which I know you're going to be doing. Are others of us allowed to listen in at the meetings of the advisory committee? Any reason for that not to be something we can all listen, show up?
Is there anybody here from the advisory committee? I would defer to their preference. I can certainly ask them. That would be my preference too.
Okay. My other questions are about these documents, because I'm also very interested in public records in my career as an administrative lawyer, and having been on both sides, working in government and on the outside and now sort of in the middle. You got some of my records, and I'm curious about some of this. The first one, I guess, is whether the dean of libraries will the Public Records Act be used, or different standards used, in determining what will be made available? And I've got a lot of questions, so that's just a simple, quick start.
Well, I know that my colleagues in the Special Collections and University Archives unit in the libraries are far more familiar with the usual processing and review standards that they have. I'm going to be reviewing all of those with them, and Not that I know all of those details at this point, but there would be standards and best practices we would be incorporating into how we would treat all records, including the President's Office records, and we'd be following those.
So if I could continue, what I could imagine is that you might have certain normal processes for what you officially put out, but that you might still have other documents that while you didn't want to put them out, they would be accessible if somebody filed a public records request.
Yes, that is true. You're correct.
And so in that regard, will there be an index created of all documents that are withheld, every single document, so at least it could be identified and somebody could say, actually, I want to know why Mrs. Jones was writing to the president, because she might not have been writing about her daughter, but about, offering a bribe or something like that. And so it would say, letter from Mrs. Jones, not available. And then we would say, maybe, I want to see it, and you would then go to the public records people.
In some of the best practices that I have reviewed for archives, that is exactly how they approach things. They have finding aids. Some of the areas would be marked as being more confidential and private, that you may have to go through a public records officer, for example, but you would be made aware of their existence through the index or the list or the finding aid.
Okay, I think this for archival, it's very important that the index be there, so thank you.
Yes.
I appreciate that.
And of course, I hastily add, all of this takes human processing as well, and so many archives have backlogs for that processing. We'll have to be examining all of that as well, our staffing levels, how much we process different collections and different parts of collections. So that's all ahead of us to try to strengthen.
Thank you. Will you be or have you received, or if you might receive any legal opinions about this, are you willing to let us see what the legal opinions say?
Legal opinions about?
About what you're allowed to withhold, or what these kinds of things.
Well, I mean, I would say probably yes, but I'd have to go along with the other institutional review, the custodians of the data.
Well,
I guess speculating about certain things, I'd have to know what that situation was.
I understand that. The reason that I wanted to bring it forward is that, first of all, there have been lawyers at this university, and there are lawyers in general, who like to say everything we're keeping is attorney-client because it's whatever we do, and it's attorney-client. Attorney-client privilege applies to facts provided to an attorney that doesn't apply to the attorney's opinions. That might be legal work product. But that is normally exempt when it is made in anticipation of being sued, anticipation of litigation, not everything that an attorney writes. And in a public institution, for example, the state attorney general often writes legal opinions, and everybody sees them, and we understand what the law is. So there's no particular reason that the general counsel's analysis of the law should be kept from all the members of the institution who are participating in shared governance and available only, for example, to, let's say, the executive branch. To the degree those are analyses, in the document that Bill put on his blog, the 12-page document, about 10 pages of it was legal analysis. It was bad legal analysis, but it was legal analysis. The last 2 pages were advice. And sorry for Bill, but under the public records law, you could probably not tell people that Randy Geller said get rid of the Senate. That could be exempt, although then we turn to the president for waiving, that and so forth. But I do think it's very important that we talk about in the Senate the legal opinions and whether everything that the lawyers do, because I would like to see a new era at the University of Oregon where the analysis of what the laws are would be generally made available. The Senate needs to know as well, and sometimes, surprisingly, people write bad legal opinions, and others people are able to show that actually a different view should prevail.
I think that many of these decisions are at a higher institutional level. I did know that at one institution where I worked, the university archives would keep legal documents and legal opinions in a separate folder even if it's virtual, but folder in the collection. And then if any interests or requests came that related to that folder, they would refer them and consult with general counsel and other people within the institution.
And I understand that. I just want to make sure that general counsel not make those decisions because general counsel, like every institution, wants to protect what it has. It's really a presidential decision on how to deal with these things. And just a final two small teaching points. Sweden, for more than 200 years, has had a wide public records law. And finally, when the computer age came in, they established public access terminals so people could monitor the conversations of bureaucrats, which, of course, they don't worry that people give legal advice, policy advice, and then other people say, well, we didn't accept it. They just let it all hang out. And similarly, President Obama, when he came into office on his first or second day of office, issued new instructions at the Justice Department that material will not be withheld strictly because there's an exemption, but there really has to be a harm caused by withholding. So I just want to suggest there are different ways to look at this, and I'm really preaching more than asking a question, so thank you.
Thank you.
There were two more, John Allen, Bill Harbaugh, and then we'll have to move on. Oh, sorry. Andrew Rubaugh.
Can I go really fast?
John Allen, then Bill Harbaugh, then we have to move on.
Hi, my name is Andrew. I'm a senior political science and economics major. Recently, Board Chair Lillis came and said he was embarrassed about the deteriorating relationship between administrators and faculty on our campus. And it seems pretty clear to me that the reason for this dynamic is the power struggle that is occurring here regarding shared governance and the seemingly constant attempts by administrators and their general counsel to cut faculty and students out of the decision-making process. In my student opinion, waiving your attorney-client privilege in these cases, especially regarding shared governance issues, student fee issues, et cetera, would go a long way toward repairing and rebuilding that relationship. And with that being said, what factors are you considering when contemplating whether or not to waive this privilege?
So let me say first, I'm a full believer in shared governance. When appropriate with students, certainly with faculty, primarily on the curricular side with tenure-related faculty. That's how universities are run, so I have no ambiguity about that. Most of the legal opinions aren't really about that. A lot of them lately have been about the ones at issue. The one that was posted was about the role, the authority of the board, and that's what the General Counsel's office was speaking to. Those things, virtually all of that, I think is worthy of scrutiny by everybody in the university community. I mean, because that we are now, in some ways, under their control as we used to be under the State Board of Higher Education. It behooves us to get those right insofar as we can adjust. And that's what we're working on now in the policy and policies. So I think more transparency is better than less, and the same thing about legal opinions. So, but I'm not prepared. I haven't been in the job long enough to know which ones I would waive or under what conditions would some kind of get into that. All right, but I take your point.
So I've been sleeping pretty well at night up until I heard John Bonine say that my release of the legal opinion from Randy Geller to Bob Berdahl might have been, I don't know, illegal. So I'm asking Scott, will you waive right now? Will you waive your executive privilege or whatever it's called, your attorney-client privilege on that one document and help this professor sleep at night?
On the spot, yes. You get out of jail free card for that one. John? No.
Thank you so much. Thank you for your remarks. So just a quick update on our strategic planning process. The steering committee of the strategic planning initiative has met twice now, January 15th and January 22nd. And the four task forces, which you know about, we've been talking about those at each meeting, have had their own process because each one has a slightly different charge. And they are not only doing what they initially said they would, but they're planning additional sessions as well. all of these efforts will now pour into our all-campus forums. And we hope that the entire Senate will be there to participate as you would like. And the first one will be in February. We'll be getting back to you very shortly with information about that and, of course, to the whole campus. But it is important for the Senate to show up for these and to lend our support and to show our interest in each of the topics that will be discussed. It is looking like each of the fora will focus on one specific topic or a cluster of topics, rather than just being any question that could be considered at that forum. So I think that it's going to be a really great process for the whole campus to go through this process together of looking at how we want to proceed as a university, who we want to be, and what our priorities are. I'm looking forward to it very much, and I hope everybody in this room and those who couldn't attend today will participate. About the Student Conduct Code, I just want, for full disclosure, to let everybody know that I got the letter today, and it will be posted. We'll scan it and post it on the website so that you can read Scott's response, which was within the 60-day period of response. But I do want everybody to know that it will be posted so that you can read it and learn about the details. And then finally, I'm going to ask Dan to put onto the screen our meeting schedule for the rest of this quarter. And as you'll see, our next meeting is on February 11th. And just to let you know that Connie Balmer, the chair of the Presidential Search Committee, reached out to me and asked if we would like on that day for the two representatives from the Parker search firm to come to our meeting and talk about the search from their perspective and receive questions. And I, of course, said, yes, that would be fantastic. And we, of course, will let the entire campus know about it so others can attend as well. So on February 11th, we will have those special guests, and you'll be able to ask questions. Then February 18th, and instead of what we had originally said, February 25th, we're not going to do that because I think we've learned that 3 Senate meetings in a row, week by week by week, it's just a little too much for us to do. And I'm sure that the schedule will flow much better if we put a week in between. So February 25th will in fact become a Senate Executive Committee meeting week. And then we'll have our final 2 meetings in a row, March 4th and March 11th. That means that you're going to remove February 25th from your schedule and put March 4th in its place. And I think it will be a much more humane schedule for everyone. And also it will allow us to consult with the Senate exec more directly, because it's very hard for us to meet more than every 2 weeks at the very most. That's due to the schedules of the individuals involved. Thanks so much. Now we move on to the next item, which is 4.1 under new business. And this is a motion, change of membership for the Graduate Council. Joe Lowndes is proposing this. He's a professor of political science and Graduate Council chair. Joe, would you like to give this to the Senate? Second, please. Who was the second? Please raise your hand. Oh, Jane Kramer. Thank you. And now I will read it. You can see it on the screen. 1.1, whereas the Graduate Council has determined that it would facilitate the work of the committee to include a member of the law school as part of the committee membership. And 1.2, whereas the current committee membership does not have a position specific to the law school, but does include other professional schools and colleges. And 1.3, whereas the graduate school has undergone recent changes in leadership titles, Section 2, 2.1, be it hereby moved that the Graduate Council membership requirements be changed to read as follows. Membership of the Graduate Council is fixed at 14 voting members, consisting of 12 elected teaching faculty at the rank of assistant professor or above, and 2 students, plus the associate dean of the graduate school, ex officio non-voting, and the dean of the graduate school, ex officio non-voting. Of the 12 teaching faculty, 6 shall be from College of Arts and Sciences representing the humanities, 2, the social sciences, 2, and the natural sciences, 2, but no 2 shall be from the same CAS department. one from each of the professional schools or colleges, which include the School of Architecture and Allied Arts, the Lundquist College of Business, the College of Education, the School of Journalism and Communication, the School of Music and Dance, and the Law School. The elected faculty members of the Graduate Council shall come from departments that have graduate programs leading to a graduate degree and conducted under the jurisdiction of the graduate school. Exceptions to this policy will be considered for members from the professional schools and colleges. One student must be from a graduate program leading to a master's degree, and one must be from a graduate program leading to a doctoral degree. The dean of the graduate school shall be empowered to appoint other ex officio non-voting members to represent important constituencies of graduate students and faculty as needed. Below follows a red-line version showing the changes from the currently approved membership. So if you take a look at each of those, the first one changing to Associate Dean of the Graduate School, then we go down School of Music, Dance, and the Law School, but crossing out, and one at-large representative from any of the professional schools, colleges. And then finally, exceptions to this policy will be considered for members from the professional schools, colleges. So those are the changes that indeed you're going to be discussing and then voting on. Would you like to give us some background information?
Generally, why that we thought that it made sense for the law school to have a member on the graduate council, since the other professional schools do as well. And the law school has graduate programs. It seems logical to integrate it into the broader category of graduate work. And we have a member of the law school now serving in an ex officio capacity, Eric Gervin, and it's been very helpful to have him there. So I think we thought it was I'm not sure what the institutional history is, why it's actually not the case, but it seemed like a good idea, I guess. I'll leave it at that.
Great. Thank you. Any comments or questions? John Bonine.
I do have institutional history. I have memoranda in my files, which I'm happy to share with you, explaining that the law school is not subject to the jurisdiction of the graduate school. And I suspect that's the reason. We have very specific discussions about this. When we approved the master's program that I've been leading for several years, we also discussed with the head of the dean of the graduate school and was able to show her the documents at that time, and that we're exempt, and that the law school relates to the president as the graduate school relates to the president, but separately. So because there is that history, and I'm not saying how it should be for the future, although naturally for my institution I like autonomy, but I also think there were reasons for that. And so I would request that this be postponed, or that temporarily we delete the reference to the law school and bring it back after discussions. But there's definitely an institutional history. We have records about this, about why the law school is not part of the graduate program in some way. So I would like the chance not to have this, when I've seen this for the first time, suddenly roll forward when in fact there are issues here. But President Coltrane wants.
I can speak to this issue, and I have seen the copies of the correspondence that Professor Bronine refers to several provosts back, and in my role as provost, I had conversations with the dean of the law school and had a different interpretation as to whether degrees offered by the University of Oregon should report through the provost, chief academic officer, and thereby have a role in the graduate council as other graduate offerings. And that was my position as provost, and that's how it worked its way up through the process. So sorry to disagree, but I think that correspondence was a particular period of time, and maybe a former provost was misinformed about the awarding of UO degrees automatically being subject to the oversight of the chief academic officer.
John Bonine.
I'm always happy for any disagreement. That's why I'm a lawyer. I do respect that point of view. I don't necessarily accept it. I don't know whether to accept it. Even if our dean said that's his position, that wouldn't necessarily take the position of the faculty. And so I would like the opportunity to review this myself and to hear the arguments. and not have the Senate act precipitously on something that at least the law faculty is not aware is happening. The law faculty, we haven't talked about this in a faculty meeting, we haven't reviewed the different point of view. So just as a matter of comity, because I think this is not time crucial, I would request that this be put off to the next meeting if you want, so that we can dig into this. And that's, I think, the whole process of working collaboratively, is when something comes up that might affect an interest, that we should make sure that everybody's on board. So if I could either request, I'll make a, see what you think about this. I'll make a motion to put this on the table until the next meeting, and then perhaps people can say whether they think it's a good idea, if somebody would second my motion.
That was Monique Balbuena.
And maybe you'd like to respond whether you think it's okay to delay this for another couple weeks.
Just to clarify, it's a motion to postpone to a time definite. Is that correct?
That's if that's what you would like. If you'd like to do it in 2 weeks, we can do it in 2 weeks. And if not, we can say until an indefinite time. I don't mind.
Yep. Yeah, I don't have a strong feeling about it, except for that it should probably be it shouldn't fall to the wayside entirely, because they last spring, for instance, the law school brought forward a proposal for a change in the graduate program that they wanted us to consider, and we were kind of not sure what to do with it at that time, and so it's probably something that really should be worked out one way or the other. I'm not sure. Again, Graduate Council, I think, does not have a strong feeling about this, except for that, well, one, it's certainly useful to have a law school representative for us for many reasons, but in terms of these are a higher order of administrative or institutional questions here about autonomy or relative autonomy that is not our kin.
So I'll actually make my motion to postpone it for 1 month. Definitely a time there. I just want to make sure we have a faculty meeting that we may be able to discuss it and see if we've got a problem. I'm aware of that new program that came in. I advised them they didn't have to go to the graduate school. They said, well, we don't want to cause any trouble. So they started down that precedential road. At any event, we'll probably all work it out, but I'm merely moving them to postpone for 1 month till the meeting that is a month from now, whatever that is.
Great. Discussion? We've already had a second, so we can have the discussion. No? Seeing no hands, I call the question. All in favor, please say aye.
Aye.
Opposed, nay. And so moved, and we postpone for a month. And may I just ask that Joe, as chair of Graduate Council, and John, at least at this moment, representing the law school, that you confer about it and work it out so that when it comes back, we're sure that we've gone through the process. That would be great. Thank you so much, and I want to thank Joe Lowndes very much for his patience. This has been on and off of the agenda for quite a while, and we really appreciate it. Thanks for your collaboration and cooperation. Yeah, great. Thank you. So we move to 4.2, which is amendment to U.S. 12/1313 UO representation on the Interinstitutional Faculty Senate, IFS. This is a returning motion, and we are now asking that it be amended. I'm going to ask Randy Sullivan, who is Senate Position 2 currently, President-elect of University of Oregon Senate, serving as IFS Senator. I can't do this as President, but I'm going to ask him to give it to the Senate, if he would. Second, please. Diane Dugas, English. And so now I will read it. And this is an amendment. Actually, rather than reading it, it's a lot easier if you just take a look at it with me. The Senate moves that the University of Oregon IFS senators will be as follows. You can see the crossouts and the additions as we read, so I won't announce each one. I'll just read the final motion. Senate Position 1, the President of the University of Oregon Senate. Senate Position 2, the President-elect Vice President of the University of Oregon Senate. Senate Position 3, a member of the statutory faculty who will serve for a term of 2 years. Senate Position 3 will be elected no later than June 1st, 2015. Future elections for the position will be held during this meeting when the election for the President-elect Vice President of the UO Senate is held. It doesn't give a term limit, so the person could come back, of course, and if that individual wanted to run again at the end of the 2-year term. And there at the bottom, date of effectiveness immediately upon approval, and it's cost neutral, of course. So that's the background information. I conflated it with reading, and open the floor for comments and questions. Lisa Raleigh.
A question about Senate Position 3. Can a member of the statutory faculty not be a senator?
It's supposed to be a member of the statutory faculty according to the way that IFS works, because it's each of the schools it's an institutional faculty senate.
So this is consistent with their language?
It's consistent with their language and their practice.
So it could be a member of the statutory faculty could be elected to this position but not be a senator?
But not be a senator, or
Yes.
could be a senator, absolutely.
Okay, that's just what I wanted to clarify that.
Great, yeah, absolutely. And most of the other schools, oddly enough, have not had senators serving. It's mostly been a member of the statutory faculty who went for election before the Senate of that particular school. So I think I'm the only sitting Senate president at the moment who is an IFS senator, and Randy's the only sitting vice president. But the other schools would like to send their leadership. They're just working it out in their senates, and some of them prefer to leave it open. The senates vary quite a bit from school to school throughout the former OUS system. Other comments, questions? Seeing none, I'll call for a vote. All in favor, please say aye. Aye. Opposed, nay. So moved. Thank you very much. And we go on to 4.3. As you'll notice, most of the motions from here on out are a kind of combination of the will to form some kind of a work group to show the support of the Senate for that. And then I'm going to ask for volunteers from the Senate to serve on that work group, and we will, of course, ask for others to come in and serve on the work group as well. But we'd like to lead that from the Senate because it shows the entire campus. It expresses to our central administration and to our Board of Trustees the role of the Senate in this policy realignment and our role in actually being involved with the work on those policies, the direct work that must take place before the policies go to the floor of the Senate. Next, we have the University Policy on Policies, which has been renamed, if you see, Board of Trustees of the University of Oregon Policy on University Policies is the new name of that. And you can see that it is quite a document with a preamble and definitions. And then you can just flip through. I know you've not had time to look at this. We just finalized the wording that we had worked out in a very collaborative and cooperative process between Central Administration, Board of Trustees, including Susan Gary, and myself and John Bonine mostly, and some others as well. Scott Pratt and Ron Bramhall and Michael Dreiling had some role in looking at the old policy and moving us forward to find language that now we can consider for a period of 2 weeks. The Senate will have to review this, each of you on your own, and we'll also put it out to the campus to see if anybody would like to offer comments. And then on February 11th, we will have our discussion and vote. Next, it will go to the Board of Trustees, which will consider it in March. The meeting is during the first week of March, Board of Trustees meeting. So I'm happy to say that if we follow this timeline, we will have beat the deadline that was given to us of February 18th for sending it to the board. So we're well on track, and it's been a great process so far, and we see this as true hope for the future. We now have a sense of how we can work and how the flow can be, in fact, enhanced between various offices, between members of the Senate, so forth and so on, in a policy-making process. So we're very optimistic about this. Yes.
I just want to say to the Senate, who may have known what I did at the Board of Trustees and other people, and a number of us in the Senate executive did, we really caused a kerfuffle at the beginning of December, and I think rightfully so. faculty governance was not, Senate governance was not being respected. And we got the board to stop. And I think many of us will say, all of us working on this will say, I think the same thing. We actually got a really good policy now. We've inserted the Constitution, references to it in various places. The process does not ignore the Constitution in any way. It follows the Constitution. It puts the Senate at an earlier stage than it was before, thereby making it less likely that there'll be unacceptable confrontation at the end, and so forth. So I want you to all to read this. We may have made mistakes. We may just not have, there may be problems with it. But I think that this is a tremendous advance. Well, it's unbelievable advance compared to where we were in December. And we may have some more work to do, but I think it's the administration and the Senate can work very well together now.
So we would like you to take a look at this in detail and direct your comments. Yes? So what we're going to ask is that if you would send comments to me or to the Senate Executive Coordinator, we're going to collect these in a document and take a look at them. Certainly the Senate Executive Committee will be taking a look at whatever comments there are and compiling those, and we'll do the same obviously for the campus. But in addition, you'll be able to participate on the floor of the Senate. But don't hold back. Let's say that you have a question as you're reviewing it over the next 2 weeks. Write to us immediately, and we can help to clarify that so that you don't have to wait until the next meeting as a senator. For the campus, we'll ask people who would like to come to the meeting to please come and participate. I think that the document is in really good shape, but as John says, there may be some items that people have strong feelings and thoughts about, and we would like to know what those are and give them due consideration. So please send your thoughts to us, and we'll proceed from there. And you'll also have a chance to participate in the discussion on February 11th. John Davidson.
I was just wondering, is there some sort of document available that highlights whatever the major changes were between the prior policy on policies and the proposed new policy?
Well, probably the best answer to that is if you pull the former document and you compare it to this one, you'll immediately see that we could prepare such a document, but it would be just very confusing. So you're probably better off just looking at this from the beginning and seeing if this document as a comprehensive entity works for you. If you want to look at the old document, by all means you can look at that, and we'll make it available. I think it's already on, we already have it. John, do you know where that is on the website?
Oh, but I want to say that the major changes here, maybe all of the changes, are all what happens in the administration. They're not changes to how we do our job in the Senate or how we interact with the president. The changes are basically that they have a different process and we come in earlier. And they have this policy advisory council. They have a different way of organizing the advice to the president. And I think to a large degree, a lot of this is going to affect things that don't involve the Senate. Other policies on campus. The ones that do involve, we're there as we've always been, and I don't recall any, I would believe me, we were always looking for that. Are we giving anything away? And no, and it turns out that once we got the conversations going, nobody wanted us to give anything away. We simply wanted to, they want to streamline some of their process or make it different, and we still have our participation, so that's part of the answer.
Yeah, and as you know, we've also worked to streamline our own process. So it's a joint effort, and I think it's working so far. We want to make sure that energy and dedication to making that happen continues. So please take a look, and please, if you do have thoughts, questions, send them to us before it hits the floor of the Senate, and also participate on that day as well. Next, we go on to 4.4, which is endorsement of 10 policies and formation of a work group on grievance procedures. Michael Dreiling, would you give that to the Senate? Second, please. Monique Balbuena, Honors College. And I will now read the policy in a somewhat shortened form, just for the sake of time, as we've done previously in other sessions recently. If you'd like to just read the whereas clauses for a moment rather than my reading them, I think that that's acceptable. Great, and then what I'm going to do, as we have done in the past two meetings, is ask the owner of this policy, which is, or rather legislation, Michael Dreiling, to explain Section 2.
Yeah, thank you. And I'm going to also, since I'm sitting next to Lisa here, also co-sponsor on this motion, really speak to, I think, the shift in attention, I think, that has come as a result of looking through the OARs and realizing that there's also a need for clarification for OAs, in particular on necessary policies around grievances and appeals, as presently there is not a clear policy pathway for OAs to conduct grievances or initiate an appeal. These serve as the closest process available to OAs. And so recognizing that, it's understood that there will need to be an evolution here on campus with the policy process, and that the motion here is to kind of hold these, which are now 13, I'll add. There's 10 specific 571s, and the motion title will need to be amended to reflect this. There are, I'm going to actually correct that, there are 11 571s listed right now on screen, 24 through 35. And those concern the grievance processes as well as some appeal processes, some of which are very specific to faculty, tenure track faculty in particular, and some of which have a broader range of interpretation that can include OAs. And it's for that reason that the remaining part of the motion, the section 2.2 below and 3, should be, oops, another another correction I see that needs to be amended is the numerical ordering of the motion. So we'll need to do that once we begin discussion here. The last part of the motion here, though, after identifying the major OARs that are under question here concerning grievances and policy procedures for appeals, we see then we want to endorse these as, yes, these are standing policies right now. They've been accepted and incorporated through the implementing legislation and right now are acting as policy at the University of Oregon. The faculty who are not represented through the through United Academics are represented then through these policies as well as our many OAs. So to retain them, to endorse them, is the first step of the motion. The second set of proposals here, and that is what's listed presently as 2.3, 2.2 and 2.3, so it should be 2.3 and 2.4, is to establish a work group, Senate work group, on grievance and appeal policies, and that work group should be composed of one statutory faculty member from the Senate, one officer of administration from the Senate, an additional faculty member, an additional OA, and one member from the PAC, the Policy Advisory Committee, and one administrative representative from the Office of Human Resources. And that establishment of that work group then has a charge that's also identified here in the motion, which is as follows in 2.3, that the charge of the work group on grievance and appeal policies to A, review the OARs listed above and identify all of the necessary criteria for grievance procedures and appeal processes as they pertain to coverage for all officers of administration and faculty not otherwise represented. We need a D in there. I see. Okay, so another late night motion writing effect. Point B, consult with the Senate Equity, Diversity, and Inclusion Advisory Committee to incorporate any recommended revisions to the following OAR, which has some perhaps dated language regarding both the discussion of prohibited discrimination regarding harassment and sexual harassment, and that there is an opportunity now for that policy advisory group to make a recommendation to this grievance work group so that that language can be updated if the work group so deems, or if either group so deems. Third part of the charge will be to propose a revision and consolidation plan and present it to the University Senate by March 11th. And the work group may determine, and this is, I think, a plan that's doable, after one reads these OARs, you can see that there are really clear clusters. There's a clear grievance process. There are appeals processes. There are specific types of processes for types of appeals, and those can be grouped together rather easily, I think. Some of those the work group may decide should stay as they are with some slight language changes and come to the Senate as standalone policies, while others may require extensive modification and consolidation so as to better and more clearly represent the needs for OAs as well as non-represented faculty at the University of Oregon. So this report to the Senate should clarify those plans for policy development and adoption. Then the charge will include drafting revisions from these texts, essentially, these OARs, into a group of policies that will assure grievance procedures and appeal processes are available for all OAs and non-represented faculty. And then lastly, present those draft policies to the Senate on April 19th, 2015. So that is the essence of the motion and the call and charge for the work group. And at that point, I guess I'd like to just make a request right now to edit the motion so as to clarify those so we don't have to go through an amendment process, if I can just do that.
Yeah. They're all minor revisions, so this is very
This is very straightforward, exactly.
Yeah.
So that's taken care of? Okay,
Yeah.
Bingo. All right, so I'll turn it over. If Lisa wants to add something, please.
I just would like to acknowledge my error. I'm so sorry. Originally, we had one sponsor, and now we have two for a very good reason, that this has been a real collaborative process. So the sponsor is Senate Executive Committee, Michael Dreiling, Sociology Senator, and Lisa Raleigh, Director of Communications, CAS Senator. Thanks.
Yes, a little backstory about the Officers of Administration point of view on this. We talked last week about the policy related to termination and resignation, and I brought up a question about whether the term academic staff also applied to officers of administration, and that's really open to debate. Some people say yes, some people say no, but this policy explicitly calls out officers of administration as this policy applying to them. And there has been, I'm not sure for how many years, but there's been a discussion between officers of administration and HR about the appropriateness of this policy for that classification of employment. And just this week, HR reached out to OAs, elected OA reps, to have a meeting to talk about this policy. And HR certainly has a vested interest in the direction that this is going. So I don't know specifically what the issues are where this is at odds with what would be in the best interest of OAs, but I think the work group is definitely the place to explore that.
Great, thank you. Open the floor for discussion, comments, questions. No, seeing none. I call. Do I see one? Yes. Yeah. Chuck Triplett.
My question is just about how the motion is organized as we've discussed at the last meeting, I believe, the endorsement of this body in many respects is a sign of support or approval. And then it's followed by a call for a work group, which I think is a wonderful idea to amend. So is the adoption or the endorsement an appropriate first step? These are already on the books, they're already in effect, or is just constituting the work group to actually go through the review and amendment process the appropriate first step, and then ultimately bringing those amendments to this body for consideration? Because again, an endorsement does imply that you approve or support them in their current state.
John Bonine would like to address that, I believe.
I think it's appropriate to keep what we've got, to know that we've looked at it and still to be able to look at it. I think it shows some progress. I think a number of us did look through it, and it's better to sort of confirm that what we have is a good start. So while I can understand that one can argue it both ways, I think it's within the discretion of the Senate, if it wishes to do so, to express its endorsement, and particularly in a situation in which it clearly says, it doesn't just say we endorse it and then we end up changing it. We actually know we're going to change it, but we're also endorsing what we've got so far. So I think that's up to the Senate to decide, and I think the Senate can go forward as Michael has written the motion.
Michael, did you want to say something? I saw your hand.
Yes, I'll just add, and I appreciate I've thought through the question that Chuck raised there as well, and Lisa and I actually talked about it as well. And the endorsement is intentional because it does, of course, affirm that there is a set of policies that now govern any grievance processes for faculty as well as OAs and in the specific ways that these policies do, that should remain intact. And until a policy revision process is fully initiated in terms of proposals and drafts, these should remain as they are. They're a good working start. They're good enough right now, but they are inconsistent and unclear in areas, and that's, I think, what the work group is going to assure gets cleared up. Secondly, there's a very likely result of this work group process producing, at least out of one or two of these kind of clusters that are in this group of policies, one that doesn't involve significant modifications. And I suspect that will be the case. And so I'm not certain, but it may be that there will be one set of those that will essentially remain as is, though with maybe a title change and something slight in that sort. So that's another reason to endorse it as is, essentially, holding that language in the present state. Okay.
Yeah, we also talked about it, and just to add another idea, that what we're trying to do with this policy realignment is also to kind of write our history as we go along, to stay focused on certain matters and to really focus on certain policies so that it's not too diffuse. And this really gives us an opportunity to do that as one of the ways that we proceed. And Michael and John have explicated some others. I see Randy Sullivan.
There's also the case that there may some cases for grievance cases may arise during the interim, and they need clear guidelines, and those guidelines should have been. It's good that those guidelines have the endorsement of the Senate. So it's important on those grounds also. Otherwise, the person involved in the grievance process may and perhaps rightfully say, wait a minute, what's the authority by which I'm being held to these procedures? And now there's no doubt about that.
Yeah, they're already enforced, but what we're doing is to say that we endorse them while we are specifically focusing on these with this work group. So any other questions or comments? Seeing none, I call for a vote. All in favor, please say aye.
Aye.
Opposed, nay. So moved. Thank you very much. I will be writing to individuals in the Senate, one statutory faculty member and one officer of administration, about serving on this working group. And then there are others, not from the Senate, who we will approach, obviously with consultation of the Senate Executive Committee. Our meeting is next week, and this will be a point of discussion. We move on to 4.5, establishment of a student-centered work group to consider policies 36 to 41, student grievance policies. The remainder of our motions today are short and sweet, as they say, so we'll just go through these as quickly as possible, and with the permission of the Senate, basically I will be presenting and John Bonine will be explaining policy matters, just to move it through rather quickly because we're really focusing on the formation of the work groups. But we will ask you to nominate yourself, volunteer, if you feel you have particular expertise or interest in serving on the work groups from 4.5 onward. Because it's so short, just why don't you take a look at it. You can read it very quickly. Section 2, I'll read it, and you can look at the whereas clauses while I'm doing that if you wish. Be it hereby moved that the Senate President appoint a Senate work group to include strong representation of undergraduate and graduate students and participation by both faculty and members of the university administration to review policies 36 through 41 and to recommend changes as appropriate. It's cost neutral, and it's through the Senate Executive Committee. So I'll ask John Bonine if he would give it to the Senate, please.
Yes.
Second, please, Jane Kramer. And would you like to explain any of the policy
first of all,
matters?
Generally speaking, for all the motions, would you click on the Policies of Senate Interest Excel workbook? Because I keep wanting people to take account of this. Things keeps evolving, and it's an increasingly useful tool, I believe. You've hidden B and C, so if you could, there you go. What we've started to do is to put in here a coloration in the C column that may help you also, that if it's blue, it's been dealt with. And now, see, I don't know, up and down or go to another tab or whatever and find some greens somewhere. That just says no action needed. That information there now. Pick something else. Go to curricular. I don't care. Go to something else. And then some things that we already that are pending right now today, for example, are in green. And it's another way of downloading this. This is the latest version, 2.8, I think, and sort of seeing where we are, which will help those of you who either are going to volunteer or to say, wait a minute, why aren't you dealing with this one, or how are you dealing with this one? So I just want you to be aware of that whole process. So now go back to the student grievance thing. So we don't know if this is a good process for students, and so we simply think that the current grievance procedure, it's time to take a look at them, and we want it very much to be a student-centered work group, one that has a strong representation of students as well, and I give it back to Rob to rattle the cage and get volunteers.
So first we need to put this into discussion. Does anybody have any comments or questions? No? Seeing none, I call the question. All in favor, please say aye. Aye. Opposed, nay. So moved. And now I'd like to call for volunteers to serve on this work group. Samantha Cohen, thank you so much. Andrew Lubash, thank you very much. Appreciate it. Two of our student senators. Anyone else? Andy Sullivan and Jane Kramer. Thank you. Thanks so much. So we'll move on now to 4.6, establishment of a Senate work group on curriculum and program matters. Again, you can see it up on the screen. Why don't you take a look? I'll just read section 2 for those who are viewing, but take a look at the whereas clauses if you have not already done so. 2.1, be it hereby moved that the Senate President appoint a Senate work group on curriculum and program matters, including senators and members of constituencies, as well as members of the university administration, to review policies 625 through 627 and 630 through 632, and any others relevant to curriculum and program matters, and to recommend changes as appropriate. 2.2, be it further moved that the same Senate work group review various unnumbered board policies, policies 493 through 514 and 518 through 519 under the curriculum tab, and recommend changes as appropriate. Cost neutral, and it's through the Senate Executive Committee. John, would you give this to the Senate, please?
So.
Second, please. Jane Kramer, and now, John, would you like to give background?
So on this, if you go to the work book and go to that tab, you get some idea of the kinds of things. This will either discourage volunteers or encourage them. I don't know which. Scroll to the top.
Encourage only, please. Encourage only.
Encourage only, yes. Scroll to the top. There's a bunch of stuff here. Now go down. Ignore the white ones. Just start going down there. So if you look on the right, you'll see, go back up a little bit. There's things about new programs, new instructional programs, off-campus instruction, instructional research, computing, keep going down, scroll down, program closures and eliminations, honorary degrees, college courses taught for credit, community college transfer, keep going. There's more work group, approval of new academic programs. There's a lot of stuff in here. Credit for college course taught in high school, keep going. Accreditation. No, not the last three. Those are a different motion. IAC, it comes later. So that's what they are. There's a lot of work. It really needs to be looked over by the Senate. It's, in a way, a core responsibility of Senate and shared governance to deal with curriculum and programs. So I hope there'll be volunteers.
This is a very important one, and it will take a considerable amount of work, but we really need your help with it from the Senate, and we'll also bring in other people as well. So now we open the floor for comments and questions. And then we'll take, after we've voted, we'll take volunteers. Any comments, questions? Seeing none, I call the question. All in favor, please say aye. Opposed, nay. And so moved. Thank you very much. And who would like to volunteer for this work group? Thank you. Theodora Crow-Thompson. Thank you. Senator Kopman and Senator McGough. Did you say your name, McGough? Please say it correctly for me so I can learn. McGew. Thank you, McGew, Senator McGew. Sorry about my mispronunciation. Having an unusual name, I get this often, so I empathize with you, and I'm the one that made the mistake. Yes. I think we could use some more on this one to divide the labor. Thank you so much, Monique Balboina. Yes. I think I'll ask John Bodine for a general assessment because you've actually looked through the policies just in a very general way.
Get it right away. Other ones, it's going to involve a lot of consultation, perhaps, with the. I don't know. We almost maybe want to ask Frances if she has some idea of what this is going to involve. I mean, it's going to be on and off. It's going to be a little bit of this, a little bit of that. And if people volunteer and you can't do it, well, if you've got a big enough committee, other people can do it. That's one reason. The more people volunteer, the less work there is.
Yeah, for this one, strength in numbers, I think. So the more volunteers we have. Thank you. Samantha Cohen. I appreciate it. Anyone else?
Scott Coltrane is going to buy banana splits for everybody who participates in this.
Any other volunteers? Thank you so much, Deborah Healy. Your last chance, going once, going twice, going a third time. Thank you so much. We really appreciate it. And we're on to 4.7, legislation to refer athletic policies to the Intercollegiate Athletics Committee. This is one where we don't need to take volunteers, but just to affirm this. So take a look at the language, and I'll just read 2.1. Be it hereby moved that the Senate President task the Intercollegiate Athletics Committee, working with members of the University Administration, to review policies 674, 679, and 680, and any others relevant to intercollegiate athletics, and to recommend changes as appropriate. Again, through the Senate Executive Committee. And I'll ask Professor Bonine to give us some background. I give it to you. Bill Harbaugh, very enthusiastic. And do you want to explain?
Okay, so now if you go back to the Excel workbook for a minute.
Just so you can see where these are.
Dan, so you just see what these three are, and there may be others. I think scroll to the bottom. So role of athletics in a college or university, academic progress and degree attachment, code of ethics. Don't all jump at once. But no, you don't need volunteers. This is IAC. The point is that these are core matters for our institutions, that academic institution, and that's why these, instead of just being endorsed, they are currently internal management directives. It may well be that these policies will evolve even beyond what's here. This is simply a starting point.
Great. Do I hear a second for this one? Thank you. Samantha Cohen was second. And now we open the floor for discussion. Comments, questions? Please, Jenny Ellis.
As a member of the IAC, I just wanted to say I can't wait.
Great. That's what we like to hear. Any other comments and questions? No, hearing none, I call for a vote. All in favor, please say aye. Aye. Opposed, nay. And so moved. On to 4.8, legislation to establish a work group on employment matters. This one is a little more involved, so take a look at the whereas clauses, and I will read 2.1. Be it hereby moved that the Senate President appoint a Senate work group on employment matters, with participation by faculty, other constituencies, and members of the university administration to review policies 42 to 44, 349, 259 to 261, 263, 268 to 291, 293 to 302, 398 to 401, 494, 637, 639 to 645, 659 to 669, and such others as may be relevant, and to recommend changes as appropriate. Cost neutral, and it's through the Senate exec. So would you like to give a little background here, John?
No, I'm getting tired enough. You can read it. Obviously, we need to work about employment matters. We need some union people in there. We need some others. And we need to make sure that these policies are consistent with what we want to be as a university.
Great. These are slightly more involved. We do need people with expertise in this particular area. Yeah, if you go to the workbook, and we'll just flip down just so you can see before you volunteer.
Until you get to your C's, and you're going to see some really important stuff here. So stop. So family relationship and employment. I think 43 is out in a different committee eventually. I'm not sure, but tandem appointments, employment of more than one member of the household. Keep going down. Academic rank, definition of unclassified service, additional pay for full-time staff. See, there's money here. Keep going. Working hours, keep going. Fellowship leave, keep going, just scroll along. Vacations, sick leave, keep going. Consecutive annual appointments, 7th annual appointment. This is all, there's a lot of really important things here. Criteria for faculty evaluation. This is every bit as important as anything else that we are doing. And it really needs some heavy thinking and people digging into this. And again, the more people you have, the more you can make little subgroups and say, okay, you two people work on sabbatical and you other people work on something else. And then maybe you work on sabbatical and say, it looks fine, we're done. But somebody needs to look at it, and I certainly couldn't look at all this and make sense of it all in a short time.
Great. Do I hear a second? Thank you, Mike Strain. And now, comments or questions? Seeing none, I call for a vote. All in favor, please say aye. Aye. Opposed, nay. And now, if you would please volunteer for this one. It's a very important one of the most important. Anybody who has expertise in any of these matters, the more the merrier. Thank you. Gordon Sayre, look at that. Great. Thank you. You can, yes, Mike Strain, absolutely. Thank you so much. Diane Dugas, thank you very much. Anyone else? Two more? Would anybody like to volunteer? Oh, Well, we've got admissions left, and we've got equity, diversity, and inclusion. So, earlier one, great. That's fine. Yeah, for the grievance one, if you could add Gina Saki. Great. Volunteers for employment. Michael? Did I hear a volunteer? Okay. And we will be looking for others also through various outreach campaigns, as usual. Okay, thank you so much. We now move on to 4.9, legislation to establish a work group on admissions. Take a look at the whereases, and I will read 2.1. Be it hereby moved that the Senate President appoint a Senate work group on student admissions to review policies 183 through 84 and 633 through 636, and such others as may be relevant, and to recommend changes as appropriate. It's cost neutral, again, through the Senate Executive Committee. Do I hear a second? Monique Balbuena, thank you. And now, John, would you like to take a look? Let's pull our policy tracker up. And
yeah, go ahead and look at the workbook under student admissions. It's off to the right. It's far right. You're probably going to have to click the right. There you go. Now keep going. I think it's that one, maybe. Now, next one. Well, go to the left and...
There it is. It's right there.
Okay.
Yep.
So, standards for admission. Affirmative action goals. There obviously have to be some coordination with other committees. Review undergraduate admission requirements. Minimum standards for entry into programs. Keep scrolling up. So here's the point. I'm not sure what you all should do with this, but I've read recently some comment on some nefarious blog that over the years this faculty has given up a role in admissions that it traditionally has had. And I think that the Senate needs to decide, is admissions just something that's going to be done administratively, or does the faculty want a role? Does it want to participate in various ways? And one way to do that is to read these policies and figure out what to do and whether there should be and I don't know what that might be. But I do think that I mean, certainly if I think of my own law school, you know, our faculty does the admissions basically. You know, we do most of the admissions. And I don't know, at the level of CAS or level of undergraduate and so forth, it's a different process. But shouldn't there be some monitoring, maybe an oversight committee, some things going on outside of simply central administration in this? And therefore, somebody needs to take a look at it, and that's why a work group is established. And it may go beyond these policies, but it's a way to get things started.
Great. Do I hear a second? Thank you, Ron Lovinger. And now we open the floor for discussion. Samantha Cohen.
So just a point of clarification for Professor Bonine. Does standards of admission include admission to individual colleges within the university, or this is just referring to admission to the university?
I don't know. Is there somebody from the administration that could tell us how the admission processes work and can answer that more? I mean, I think that I know there's a policy there on undergraduate admissions requirements. I don't know. I suspect that that there's a delegation process that either exists or should be formalized that should say, these people deal with this, these people deal with that. But anyway, we can give the
Dave
thing to
Hubin.
Dave Hubin.
Chuck Triplett may be able to speak to the IMD aspect of this, but these four probably deal much more directly with admission to the university. But the Senate has a critical role and should take an active role in questions of major requirements. It did 15 years ago when we had majors which were oversubscribed. We had people who couldn't get into professional schools. That's within the Senate purview to discuss. It's an academic matter. But these four up here are going to be broad brush admission to the university. It's also clearly an academic matter.
The motion, so you understand, the motion says something like, and such other, or should say, and such others as may be relevant. So this is just the entry point. Yeah.
And one more comment.
Yes, please.
Well, I think you'd find if you looked at comparator institutions, for example, the various University of California campuses, you have faculty involved in setting broad policies with regard to admissions. And it's something that we should be looking at.
Yes, and as you saw, these were OUS policies, of course, that were for all of the campuses, and now, of course, we want policies that will relate to our own campus.
As far as I can tell, we don't have any policies that have been officially adopted here. That leaves us really out in the woods.
Yeah. So this one is an involved one, very, very important, obviously, and has to do also with visioning where we want to go, who we want to be in terms of policy related to this topic. Comments, questions? Jane Kramer.
I don't know a lot about this, but I do know it's been discussed as an absolute brand new thing now, including like admission of international students and stuff like that, that we have some different standards from our comparators. So I'm just saying, encouraging people, this is a big one. It's going to be all new.
Yeah, and really important because we have an Office of Enrollment Management, so certainly there'll be interaction with that office and other offices of the administration. Just trying to understand what our policies are now and what needs to be moved forward into a more formal kind of policy that's written for our specific university. So other comments, questions? Seeing none, I call for a vote. All in favor, please say aye. Aye. Opposed, nay. So moved. And do we have volunteers? Thank you so much. Ron Lovinger, Theodora Coe-Thompson, Senator Saros, Senator, what's your name? Iverson, and we need to make an ID tag. I think you're one of our new student senators, right? Let's have a hand for him. He volunteered. We had some students who had, because they have a class at this time, who had to step down. So he's one of our new ones, and I think another one will be chosen tonight, is my understanding. Is that correct? Or Andrew, yes. Andrew Lubash had informed me about this. Other volunteers? Senator Rajai and Robin Clement. Senator Clement, thank you. Others? No, thank you very much. That's really helpful. And now we move on to 410, legislation to refer discrimination policies to the Senate Committee on Equity, Diversity, and Inclusion. Take a look at the whereas clauses, and I will read 2.1 and 2.2. Be it hereby moved that the Senate President refer discrimination policies to the Senate Equity, Diversity, and Inclusion Advisory Committee to review policies 228 through 256, 348, and such others as may be relevant, and to recommend changes as appropriate. 2.2, be it further moved that the Senate President refer policy 35 to the same committee for consideration of possible changes as appropriate. Cost neutral, sponsors a Senate Executive Committee. Do I hear a second? Who is that, please? Oh, thank you, Diane Dugoff. And now I'll ask Professor Bonine just to talk about that.
Discrimination tab, blue tab at the middle there. Yeah. Go to the top, start at the top. Okay, so there's definition of discrimination, for example. How long has it been since that's been looked at? And that was looked at the state level, not at the university level. Scroll upwards. Up, 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 up. No, you're going the other way, okay? No university policies? What? No 571? There may be up in the policy library, but obviously we need to look at these state board policies, bring them down into our institution, decide whether they are modern, whether they, for example, represent all categories, LGBTQ, these things, and we need to know whether the processes are right. So, and look at some of the topics there. Marital or parental status, keep going. Comparable facilities, investigation of complaints, No longer is there a chancellor to appeal to. Keep going. A written statement of the case, a conduct of the hearing. There's all kinds of stuff here. Keep going, because I think there's a requirement of prompt attention to complaints, and then the discrimination category. So this needs to be looked at seriously, and we're simply putting it in the committee that we talked about in the last meeting.
Yeah, and in this one, we would also like to ask for volunteers if there's anybody who would also like to serve, just because it's such an important one, and there may be others as well, from the Senate in particular. But before we do that, comments and questions? Michael Dreiling.
Yes, I would like to request a slight amendment to the motion, and I'd like to do that to specify that the policy number 35, so this would be a yes, exactly, that this policy number 35 to the same committee. Okay, you're going to open it up here. Okay. As appropriate by March, what was the date on that other one? 12th.
Do you mean Senate meeting date? They're on the 4th and the 11th.
Right. So my
March 11th?
request is for this amendment allows or encourages the advisory committee here on diversity, equity, and inclusion to review policy 35 with some urgency, so that the work group on grievances can have input on suggested changes to that policy before they proceed with drafting grievance policy language. So I think that's, yes, by March 12th, 2015, in collaboration with the work group on grievance and appeal policies.
Great. So we have a proposed amendment. Do I hear a second? Jane Kramer, and now discussion, please. Lisa Raleigh.
Question about the date. So that's the date after a Senate meeting? Is that what you mean?
I'm just coming off the top of my head. It should be 11.
Okay, March 11th.
So March 11th, please. Great. Other comments, questions? John Bonine?
Is the changes by March 11th, or is the plan by March 11th and the changes by April? I'm trying to remember back to the other motion, which I thought changes by April 29th. So this is for consideration.
You could just add "and changes by April 29th."
Well, no, or we could say in accordance with the process in the other motion. I mean, it's really formulating a plan by March 11th, isn't it?
Formulating a plan which will require discussion.
Well, but is it, I guess my question is, would it be something like, for consideration of a plan for possible changes by March 11th and action by April 29th? Okay. Of a plan for possible changes as appropriate by March 11th, and then after the date, after the 2015, and for action by April 29, if I remember correctly.
Yes, by April 29 in collaboration.
Yes. Good.
Don't you have to put the and for action after the in collaboration with, or not? Nope. As is. Good. Excellent. Great. So, yes? Right. It's a second amendment, so we need to... So we move to amend the motion to amend. A second, please, for that. Jane Kramer, and now discussion. Call the question. All in favor, please say aye. Opposed, nay. Now we can have discussion on the main motion. No, that was just to, okay, so now discussion on the amendment to amend, yes?
It's not really a big discussion. I just wanted to ask you to add a comma after appropriate before March 11, as appropriate, comma, by March 11. And then perhaps the end before in collaboration is not necessary. Yes, you know.
With all due respect, may I suggest that we try, whenever possible, not to make grammatical changes, because that will require another amendment to do the commas. And although it's grammatically bad, I will share with Michael responsibility if he wishes for making grammatical mistakes.
Okay. Okay.
Great. So let us just proceed. Questions, comments? No. Seeing none, I'll call the question of the amendment to amend. All in favor, please say aye. Opposed, nay. So moved. We return to discussion of the policy itself, rather the legislation itself. Any discussion? Seeing no hands, I'll call the question. All in favor, please say aye. Opposed, nay. And it's so moved. And now could I have just one or two, for this important one, to add to this group, volunteers, if needed. We really would appreciate it if there are people who would be interested. Senator Serros, Senator Kramer, Senator Lee. Anyone else? Senator Cohen. Thank you so much. This is enormously helpful. It's been an incredible meeting today. Just think of where we have journeyed together. I mean, this is incredible. 3 weeks, and look at what we have achieved. Bravo to you all, everybody together. And we will now adjourn. And I would just like to say one more thing. If you take a look at Notice of Motion, you'll see that there is a new motion by Frank Stahl. I won't take time to read it, but just to let you know that it's there. And there will be 2 motions coming before us. We'll send them out to you shortly. Thank you so much for a great meeting today, for your service. Thank you.